and the commemoration of the 10-year anniversary of the Constitution of Kenya 2010. I want to welcome you all to today's session. We're going to have an exciting discussion. Today's topic, we will be discussing the politics of the amendments to the Constitution. And today we have our keynote speaker, Ms. Atsango Chesoni. Atsango Chesoni shouldn't be a name that is strange to any of us, because she has been a critical part of the constitution-making process in Kenya. Atsango Chesoni is a lawyer. She's also a human rights monitor. Her passion is constitutionalism, human rights, and equality. She was a delegate in Bomas, the Constituent Assembly that brought the Bomas draft, representing women. And she was the deputy chair of the Committee on the Legislature in Bomas. She is also she served as the deputy chairperson of the Committee of Experts on the Review of the Constitution, the Constitution of Kenya 2010. And she maintains an interest in constitutionalism, human rights, and equality law. This topic is a topic I think is of great interest to many of us, because from the time of the Saba Saba, we know that Saba Saba was all about return to multi-party politics, the demand for the expanded democratic space, the expansion of civic space. And Kenyans remember, because it's in our most recent history, Saba Saba, and of course, Nane tomorrow we will be commemorating that agitation that gave us what is known as the Second Republic. And so Kenyans are interested in the politics of constitution making. And I encourage you all to engage actively. You may ask your questions or make your comments in the chat box for those that are streaming in via Zoom. For those of you who are streaming in via YouTube, you can ask your questions or make your comments, and we shall receive them on this end. Those of you who wish to tweet, please feel free to tweet. Hashtag Tekeleza Katiba, which is the theme of this series of webinars and the month of Katiba Month. So with that introduction, I want to welcome Ms. Atsango Chesoni to make her keynote address, and then we will pick it up from there. Atsango, welcome.
Thank you, Daisy. First of all, I'd just like to say thank you to Inuka for providing me with this opportunity and inviting me to speak with you all today. And Daisy, thank you. It's a pleasure to see you again and to speak and reunite again with all the friends at Inuka. And thank you to everybody who's joining us this afternoon for being here. So I'm just going to begin by talking a little bit about, in general, what the Constitution is and why we had it and what's unique about it. So basically, the Constitution is the basic law of the land. And it sets out the rules and the basis on which we as citizens engage with the state and engage with each other and with those who we have chosen to represent us. The thing to remember is that because we are a republic, power vests in the people. And so we donate and we give the opportunity to others to represent us. But at the end of the day, this, sovereignty and power rests and vests in us as the citizens. Now, when we talk about the new constitution, which is the constitution that was promulgated on August 26th, 2010, it is new in relation to the fact that it isn't the first post-independence constitution that we've had. Our constitution was originally negotiated as part of the independence process in 1962 in Lancaster House. we had people that went to Lancaster House in England as part of the independence negotiations. Those people were drawn from the Legislative Council, what is known as the LegCo. And this is one of the primary differences between the Constitution 2010 and the 1962 Constitution, which is the one that this Constitution overhauled and repealed, basically. What is the difference that I'm alluding to here? Whereas the people of Kenya participated in the drafting of the current Constitution, the people of Kenya gave themselves the current Constitution. The previous Constitution was a negotiated document primarily intended to deliver independence. And this isn't unique to Kenya. When you look around East African countries, you will see, and it's not just, the East African countries, any of the countries that is a former British colony, you will see what are known as the Lancaster House constitutions. And they're quite similar. The people in the Legislative Council had generally been nominated. And you know that up until independence, Kenya had been a segregated state, where we as the African majority actually didn't have the right to choose our representatives. So even that was negotiated over time. Initially, the first African parliamentarians were nominated. The first Africans who served in the Legislative Council were nominated. And they were nominated pretty much by the British, basically. And so you have this group of people who then go to Lancaster to negotiate on our behalf. Another characteristic of Lancaster is because of how the delegates in Lancaster got there. One of its characteristics is exclusion. So we only, for instance, have one woman delegate going to Lancaster, Priscilla Bwao, and even she is not allowed to speak. So no women, for example, spoke in Lancaster. That's like over half the country's population were excluded from that negotiation. And it's just simply the most glaring example. Of course, again, there was no effort made to ensure that persons with disabilities or young people were speaking because of the time and the way in which that conference was constituted and negotiated. And its primary purpose, again, being independence. So at independence, under the old Constitution, in its original form, because it was also amended many times over, but at independence, our system of government was a parliamentary system of government. We had a prime minister. Jomo Kenyatta assumed office as a prime minister. And so in a parliamentary system, you have an executive that's bifurcated. You have the head of state and the head of government are not one and the same. So in that transition from the colonial era initially, the Queen, of course, remained the head of state. But eventually, in most states, you would have a prime minister and you'd have a president. We also had a bicameral legislature. What do I mean by bicameral legislature? It means that Parliament had two houses, a Senate and a National Assembly. So at independence, we had a Senate. At independence, we had a prime minister. And we had a multi-party system. Between 1963 and 1969, several crucial amendments were made to the original Constitution. One of those amendments resulted in the fusing. We switched from a parliamentary system to a system that was neither parliamentary nor presidential. It was a mixture of both. As the constitutional reform movement grew, we began to refer to this system actually as a mongrel. The reason why that kind of derogatory language was being used is because under this system, the presidency the executive amalgamated all sorts of powers to itself. And so the checks and balances that had been there in the independence constitution were removed and eroded. And they created this very powerful office, which, although they were calling it a presidency, it actually had no checks. It had very few checks on it. You know, the executive under that constitution was so powerful, it could create or abolish any office. And if you want to understand the extent of the absurdity of this kind of power, the office of the Chief Justice, which was not properly entrenched in the constitution, could have been abolished under the old system if we had a president that chose to do so. In addition, there was no requirement, actually, that even your Chief Justice be a lawyer. And this is just one of the examples. The original independence constitution had vested some level of independence vis-a-vis the police. That was removed. You know, these are some of the kind of amendments. We had a Bill of Rights in the Constitution that recognized various areas of human rights, but the problem with it was it wasn't enforceable, it wasn't justiciable, because in order to rely on the provisions of the Bill of Rights in the old Constitution, you had to get permission, and one had to go to the Chief Justice, who was required to make rules to enforce the Bill of Rights. No Chief Justice until 2000 of the Republic put in place the rules. And so we had a situation where not only did we have a Bill of Rights that wasn't justiciable, but now with the amendments, we also had some of the limited rights that had been provided for under the old Bill of Rights being proscribed and further limited, because you could limit rights on the basis of health, security, which was very common in terms of limiting the right to freedom of expression. Very often it would be used as an excuse for that. And so now, one of the most important rights that then got proscribed, and one aspect of the original independence state that got changed, was we moved from being a multi-party state to becoming initially a de facto, which means in practice, a one-party state. And then finally, after the 1982 coup, we actually became a de jure, by law, one-party state. So the seeds for us becoming a de jure one-party state were planted way back in 1965 with the proscription of KPU. KANU and KADU became one. And eventually when Oginga Odinga and some of the other actors who were considered to be dissidents attempted to ensure that we continue with multi-partyism, they were placed under house arrest. All of this happening in the 1960s within the first 5 years of independence. And so by 1969, most of those safeguards, the democratic safeguards, had been removed. And so we must be very careful when the political elite begins to engage in discussions that are exclusive about negotiating the Constitution. Because as we can see, it, you know, at independence, the original Constitution, the old Constitution, in as much as what we were seeing in the 1990s was problematic, the original document in 1963 actually contained several safeguards that were removed in a period of less than 6 years. And so the path to destroying democratic freedoms can actually be very fast. And the reclamation of those freedoms is actually a very long journey. And so what we must guard against is the removal of those safeguards even in the first place. And so these are some of the things that informed the way in which the current constitution, the 2010 constitution was negotiated. It was that history of oppression, that history of exclusion. This contestation was a violent contestation. It was a contestation that resulted in people being detained without trial. Initially, mostly artists like Abdulatif Abdallah, Wasonga Sijayo, and then people who were basically considered to be dissidents, people who seemed to be speaking outside of the norm. And so then you see Martin Shikuku being put in jail and Ngugi wa Thiong'o, who, you know, I think most people are quite familiar with those two. And, you know, Serene and other political thinkers. And here's the thing to understand, that the difference between then and now is that these people couldn't even rely, because of the amendments that had been made, they couldn't even rely on the constitution. They couldn't rely on the law. They couldn't rely on protection from the law, because there were several safeguards that had never been in there originally, or if they were there, had been removed from the Independence Constitution. And so in 1978, as we all know, because Jomo Kenyatta had basically arrogated all these powers to himself, and the office of the president had actually become personalized and extremely powerful. And so then in 1978, Jomo Kenyatta passes away, and we have a transition. And Moi comes in, who was the vice president. And around that time, there was an attempt to amend the constitution, to amend it to prevent Moi from coming in, to amend it to prevent the vice president from coming in. I'm mentioning these things because, again, it's important to notice another trend, that whenever we have an obligatory transition, one that the elite cannot negotiate its way out of. Now, in 1978, caused by the president's death, you then have this movement around the political elite, the constituency within the political elite that feels most threatened by the transition, seeking to change the constitution to suit them, to enable them to perpetuate themselves. And so finally, in 1982, after the coup, Kenya became a de jure. After the attempted coup, Kenya became a de jure one-party state. That means in law, it was now a one-party state. I've talked a lot about the traditional instruments of power and exclusion in a way in which affected all of us as a populace. But it's important to remember and know that the original constitution did not protect certain groups. When you looked at the original constitution, the 1962 constitution is the one that I'm referring to as original. The 1962 constitution did not expressly protect women from discrimination on the basis of sex. So you have sections of the population that are actually not citizens. Women were not citizens under the old constitution. Under the old constitution, one was a citizen by virtue of either being a man or married to a man. You had to be the child of, and it said specifically the son. And so we have half the population not even enjoying citizenship status. How does one negotiate in a context where one is not even a citizen? And so that is the most glaring example. That constitution did not recognize socioeconomic rights. And so we have portions of our population that historically have been excluded. And because of our colonial history, there are parts of the country which historically the colonial, the British did not find quote unquote useful to themselves. You know, I'm talking about places where they couldn't, because remember the British's agenda in Kenya was extraction. And so the parts of the country which did not produce that which they needed to extract, largely agricultural produce, those parts of the country were not useful to them. And you find they were not developed in the same way that other parts of the country were. So for instance, northern Kenya didn't have the same number of schools. The infrastructure did not allow them to be able to access Nairobi. They were cut off in terms of infrastructure, in terms of access to educational facilities, in terms of access to health facilities, etc. So by the 1980s and definitely today, we have parts of the country whose level of development, we have an uneven development in the country, because even after independence, the post-colonial regimes did not understand the importance of ensuring equitable access to all these, to services, to social services, and to the democratic process. So we have large constituencies being cut off just by virtue of the place in which they were born, for instance. So after the 1982 coup, we have the amendment, and we have, because the Moi regime was extremely nervous at this point in time, we have increased and large amounts of our population being incarcerated. We have massive violations of human rights occurring. The repression of people who were considered to be part of Kenya, people being put in detention, being disappeared, not even being tried at all, because of course there is no offense they can be tried for. Their actual offense from the perspective of the regime of the day is that they hold a different opinion. And you have it, and so in this climate, there begins to grow an increased demand for an opening of the democratic space. And this culminated, because we don't have time, and I don't want to go too much into that history, but I think it's important for us to just understand the historical context. So I'm brushing through things that are quite complex, but because also of the pressure of time. And so the culmination, so I'm just going to mention highlights, basically. So the culmination, of course, of this is all in 1988, when we have the notorious Mulolongo election, because by then we are a one-party state. In order for you to access anything, you have to belong to KANU. And you have all those things happening where we have life membership of KANU. And so there's that election where the Mulolongo election in 1988 was an election where people literally were lining up behind the candidates of choice. So the whole secrecy of the ballot is not guaranteed. And the electoral process, the process by which the people are to choose their leaders, is probably at an all-time low in terms of the history of the country. And so that was the straw that broke the camel's back. And so you have the beginnings, and this is coinciding with movements across the globe, and particularly in other parts of Africa, where you begin to have the push for multi-party democracy. And Kenya is one of the countries, initially it starts off in Zambia, in terms of countries where we see it actually happening on the continent. But, Kenya is one of the countries where we have this push. And so there's a lot of agitation for a multi-party democracy. And so the Constitution is then amended again in 1990, now to repeal Section 2A. Section 2A had been the one that had made us a de jure one-party state. And so the Constitution is repealed, to make us I'm sorry, I saw something just pop up. And I will answer questions as, after I finish this. But the Constitution then is amended to repeal Section 2A, and we now are a multi-party state again. And this happens in late 1991. All of this after the 1990 Sabasaba demonstrations, which we're commemorating through this series, whereby, Charles Rubia and the late Kenneth Matiba, they all, Oginga Odinga, they all pushed for us to have a multi-party state. Several actors, several of those who were pushing were incarcerated. I think we all know the severe disabilities that Kenneth Matiba suffered as a result of his incarceration. And eventually their agitation bears fruit. And in 1991, late 1991, Section 2A is repealed, and we go to the first multi-party elections in decades in 1992. However, Moi has been able to successfully argue, even though we are having a new election, that he is starting a new term. And so his old terms don't apply. And so he is eligible to run. And we know about the violence, the pre-election violence that happened, where large populations, many of our people are displaced in Enusupikia and in Mayela. And, the mass violations again that are suffered, the atrocities that are perpetrated in the lead up to the 1992 election. And so these contestations around the state have been historically very violent. So very quickly, the people of Kenya realize that even though we are now a multi-party state, the only thing that has changed really is that people from different political parties can contest. But we do not, many of the things that keep the repressive colonial state are still intact. And that the post-colonial state, the Kenyan state remains unreformed, despite the independence constitution, despite the repeal of Section 2A. We still have things in place like the Chiefs Act at that time. We still have the Public Order Act, which prevented people from being able to meet, to demonstrate, to agitate for their rights. Even looking at even accessing the Constitution at that point in time, even that is an act of dissent. Because in those days, if you went to get a copy of the Constitution from the government printer, you'd be asked why. Why do you want the Constitution? Lawyers are not required to even study. One could become a lawyer without having ever read the Constitution of Kenya at that point in time. And so the management of the electoral process itself, for the first time in 1991, we now have an independent electoral management body. I'm saying independent in inverted commas. Independent in the sense that up until 1991, the electoral management body was housed. It was a department in the Attorney General's chambers. The president at this point in time has control over when it is an election is called, whether or not parliament can be prorogued. In fact, the president used to refer to it as his weapon, his secret weapon. And so the opposition and the people of the country, the needs of a segment of the political elite coincide with the needs of the majority of the public. And what does that need? The people of Kenya understand and have a substantial element within the political elite that understands that in order for us to actually enjoy democratic freedoms, we are going to have to overhaul the Constitution completely. That the Constitution in its form, the 1962 Constitution in its now tattered, amended form, is incapable of birthing a truly liberatory state. It's incapable of ensuring a genuine republic and a genuine democratic state. And the people do not, even though in theory they should be, the people are actually not the sovereign. The power has been annexed and personalized to an extent whereby it is the political elite and a small clique within the political elite that actually holds power. And so we begin the reform movement in 1997. This crystallizes in a movement where the declaration is no reforms, no elections. And we wanted several elements of the then constitution repealed and the constitution completely overhauled in order to not only to guarantee multi-party democracy, but to ensure that all Kenyans are citizens, to ensure an inclusive and participatory democracy in which we as the people determine how we are governed, to ensure a justiciable Bill of Human Rights. We didn't want any other Kenyan to ever be put in jail without a trial. And, to ensure freedom of conscience, freedom of expression, to ensure that our land is ours, because this is originally why Mau Mau fought. This is originally why we had the independence movement. And yet, as of 1997, as recently as of 2010, we had land that had been arrogated and could be held for 1,000 years. We all know about those clauses again. And so we have the no reforms, no elections movement. We had the people's movement had been working through the Limuru conferences, where under the aegis of the National Council of Churches of Kenya, we had people meeting and using those spaces because those are some of the only spaces that actually were under control of the citizens, and working on what it is, what kind of a constitution we'd like to have. And so it had culminated in the Fungamano meetings. Now, under the aegis of religious actors, because we had the religious organizations being quite active in the democratic space at that time in a positive way. And so we had demonstrations that were happening during the course of 1997. But then again, we have the political elite choosing to go into negotiations with the Moi regime. And so they introduced what they called a minimum reform package to facilitate the 1997 elections. Civil society and the general constitutional reform movement felt betrayed by the political elite in this process because they were not pushing for what we had wanted. We wanted comprehensive reform. There was now a bifurcation within the constitutional reform movement, where elements of the political elite chose instead to go in and negotiate for what they called a minimum reform package. And so we had the Interparliamentary Parties Group set up, also known as the IPPG. There were some amendments made, particularly in relation to the Public Order Act, in relation to the Chiefs Act, in relation to requirements for the nominated members of parliament, now requiring that we should have 1/3 women, and an agreement to set up a body that would oversee the constitutional reform process. But because of this bifurcation within the reform movement, the people that were being appointed were not necessarily trusted by the public. And so there was an agreement to invite Professor Yashpal Ghai to now become the chair of the what had been known as the parliamentary the parliamentary committee. A parliamentary committee had set up a Constitution of Kenya Review Commission. Professor Ghai was invited to chair that, but because of the lack of legitimacy, he was not willing to take up the chairing of that process until the various actors within the reform movement, particularly those who had been working through Fungamano, where we had set up what was known as the People's Commission, were brought on board. And so he negotiated that uniting of the Parliamentary Commission with the body that had been set up by Parliament with the People's Commission. And so we ended up with the Constitution of Kenya Review Commission, which under the Constitution of Kenya Review Act which was then amended now to set up that body and to set up the organs of review and to usher in this new phase of constitutional amendment and reform. And so we had the Constitution of Kenya Review Commission set up with Professor Ghai as the chair, and with some, I think it was 20, I'm sorry, I don't quite remember. I'd forgotten to revise this, but it was some 21 commissioners. And so then this is the body that now went around the country collecting the views of Kenyans on what it is they felt should be in the new constitutional order, what they felt the new constitution should look like. And there were laws about what type of new constitution we should have. So the CKRC did not operate in a vacuum. They didn't just have a free hand. Under the Review Act, for example, we had to have a democracy. The principle of separation of powers had to be incorporated. We had to have some level of decentralization. So the seeds of what is now devolution were then planted then, because at the local level, it was important, and we felt that the people must reclaim their power. The Review Act also had to provide for equality and for a justiciable Bill of Rights. It had to ensure that during the process, the Review Commission had to make sure that there was equality of opportunity for participation by persons with disabilities, women, the youth, those constituencies which historically had been left out, those who are marginalized. They had to, by law, ensure their participation. And so we have in Kenya a very unique constitution-making process because it was people-based, because of the history of the way in which that process came about. And so the CKRC was charged with coming up with a draft. This draft was to be taken to the National Constitutional Conference at Bomas, where again we were going to have representation from across the board. It was probably the most participatory body we had ever had in the history of this country, because the delegates to the National Constitutional Conference were parliamentarians. Then there was what were known as the district delegates. Each district had to choose, and we had some 71 at that time. Each district had to choose 3 people, one of whom had to be a youth, and one of whom was meant to be a woman, had to be a woman to represent it. And then we had a group of delegates to represent civil society and other actors, including 20 women who were nominated to the National Constitutional Conference, because we knew that Parliament at that time was overwhelmingly male. It's still predominantly male, but at that time, women were only nine. I think we only had nine women parliamentarians. And so there was no way the organs of review, the National Constitutional Conference as an organ of review, would be able to satisfy the 1/3 minimum principle, gender principle, which we had agreed by then was one of the minimum principles for the organs of review in its natural state, because of Parliament, the way Parliament was made up. And so the Constitution of Kenya Review Commission under Professor Guy developed a draft, which draft was to be taken under the Review Act to the National Constitutional Conference for ratification. Originally, that was now meant to become the Constitution of Kenya. And so the National Constitutional Conference began to sit in late 2002. President Moi chose to prorogue Parliament, which then disrupted the National Constitutional Conference, because the National Constitutional Conference could not continue to sit. I would like to just point out 3 characteristics of the Guy draft that are important, I think, in terms of understanding the politics of constitutional amendment. 1, that draft provided for a parliamentary system of government. Secondly, it provided for devolution and a bicameral House of Parliament, a 2-chamber house with a National Assembly. And so when people call for the Boma's draft, it's important to understand these are the things they're actually asking for. It provided for a bicameral House with a National Assembly and a Senate. It provided for a very strong Bill of Rights. In fact, very little has changed in the Bill of Rights between the draft that Professor Guy developed, the Constitution of Kenya Review Commission developed, and the current Bill of Rights. It also provided for limited terms of office for the president, a strong system of checks and balances with constitutional commissions. And therefore, because this was the promise of the new constitution was such a powerful force, and the promise of the guarantee of these rights was so strong that when President Moi then prorogued Parliament, the chant that broke out at Bomas in 2002 was "Yote yawezekana bila Moi." Everything is possible without Moi. And so NARC, the National Rainbow Coalition, the Kibaki regime, came in on the promise of a new constitution. In fact, President Kibaki promised us that within 100 days of his election, we would have a new constitution. And the Kibaki regime then reneged in 2003. And we know that by 2004, the tensions around the constitutional reform process was so great that when the Boma's draft was passed, it was on the cusp of the government of the day having walked out of the National Constitutional Conference. And so they did not present that draft to Parliament as they were obligated to. Now, the Boma's draft was quite similar to the Guy draft in terms of proposing a parliamentary system, in terms of proposing again it kept intact the constitutional commissions, it kept intact a system of devolution, It kept intact a bicameral parliament. It kept intact many of the checks and balances again. And so after the Boma's draft wasn't presented to Parliament, we then have another process instituted, culminating in the referendum in 2005, which we all know the Kibaki regime lost because most people voted no over a new draft that had been brought that sought to introduce a mongrel system, not quite a presidential system, but again, not quite the parliamentary system, and which greatly undermined the gains that had been made vis-a-vis devolution in the Boma's draft. And then we all know the history of the 2007 elections and the post-election violence that occurred, which was the worst that we had had. We had had pre-election violence before, which resulted in numerous atrocities, but Kenya had basically, the level of tension and conflict had been building up over time. And now with each reneging by each regime on the promises of, on the democratic promises, we now had hit a powder keg. And so in 2007, we had the post-election violence. And as a consequence, we had to have the reconciliation undertaken by through Kofi Annan, Mkapa, and Graca Machel, through the Committee of Eminent Persons sent here by the African Union and the international community. We had to have that intervention. And so out of that came the National Accord. And the National Accord amended the Constitution again. Now, under the National Accord, there was something known as the Agenda 4 items. These are the issues that were discerned to have been the long-term causes of conflict and violence in Kenya. And one of the issues that was identified was the Constitution. Now, the lack of reform of the Constitution. Now, the old Constitution in it of itself was a problem, but also to address many of the other Agenda 4 issues, one needed to reform the Constitution. For example, again, the whole question of inequality, including the ethno-regional inequalities. And so the Constitution was amended to set up a government of national unity with a prime minister. And one of the things that was committed to under the National Accord was to begin the constitutional reform process again. And so a legislative framework for a new constitution and for a roadmap to a new constitution was enacted in 2008, late 2008. And in 2009, under the Constitution of Kenya Review Act, now 2010, which was really a revised version of the original Constitution of Kenya Review Act of 1998. Excuse me. We had the committee, we had 3 organs of review set up, which was the Committee of Experts, which was the technical body that was to draft the Constitution, the Parliamentary Select Committee on the Review of the Constitution, and Parliament itself, 4 organs, Parliament itself, and the referendum, 2010, through which the new Constitution was to be voted on. And if the majority of the people voted in favor, we would then have a new Constitution. And, excuse me, And so we had the committee of experts set up and the PSC, the Parliamentary Select Committee on the Review of the Constitution. And we then now had, under the committee of experts, we were required to identify what had been known as the contentious issues. These are the issues which, when you look at the Guy draft, the Bomer's draft, and the 2005 referendum draft, the issues where there appeared to be conflict. And most of those issues were actually around the system of government, around devolution, which was resisted because the centralization of power had meant that, again, that small political elite clique, that small clique within the political elite could continue to dominate and have access to the resources. And the transition clauses. These were the main areas of contention in actuality. And so we all know, I think, that we then had a draft written and developed by the Committee of Experts, which draft was shared with the public in December 2009. And then their views were collected and amendments were made to that draft. And that draft now was submitted to the Parliamentary Select Committee on the Review of the Constitution, which sat in Naivasha. It's important to know that the draft that the Committee of Experts sent to the Parliamentary Select Committee also provided for a parliamentary system. That draft, that system of government was rejected by the parliamentarians when they sat in Naivasha. And they decided that they wanted a presidential system. And so we ended up with a presidential system. And the new constitution was promulgated in August 2010. Under the new constitution, we have a presidential system. We have a justiciable Bill of Rights, which, amongst other things, entrenches the principles of equality and inclusivity and participation of the people. We have an independent judiciary under the new constitution, under the current constitution, and we have a legislature. We also have provisions under the current constitution that require and that provide for rules in relationship to leadership and integrity. Whether or not those requirements have been respected, of course, is a different issue. And I think that's something that we're going to discuss now as the process goes on. And so one of the things that I personally am proud of as a Kenyan is that, unlike many countries, we have a situation in Kenya where the people imposed a constitution on the political elite. And this is where I want to end. That it is the people of Kenya that decided what the terms of reference should be. And therefore, we have a very unique historical situation. And when we hear demands around constitutional amendment, we need to look at them in the context of, is this an attempt for the political elite to ensure that it reclaims a space which it enjoyed previously, that the new constitution does not allow them to enjoy on the same level? And so I would like to stop there and maybe seek guidance from you, Daisy, as to how we proceed. Thank you.
Thank you so much, Atsango. I didn't even want you to stop. You're like a walking encyclopedia. You're like a walking history lesson. Thank you so much for great insights, because I think that, especially at the time we are at as a country, where once again we are discussing an amendment to the Constitution, it's important to remember the journey that has brought us to where we are. And I think that for me, just listening to you, the importance of understanding our history really comes out. And I think that it's unfortunate that so many people don't really know this journey or are not acquainted with it, so that they appreciate what we have today within the framework of the Constitution that was given to us by the Committee of Experts, of which you were the deputy chair. For me, I think that the things that really, really stand out for me, and in relation to where we are, is what you say, that whenever we have, when we come to a point of obligatory transitions, the political elite organize around how to retain power through constitutional amendments. I think the only person that we saw who didn't do that was Kibaki, but then his government is the one that gave us the Constitution 2010. The other thing that stands out for me is the importance of the law and the Constitution in ensuring predictability. But I think the other thing is that we must also put the rider that predictability only comes when we have leaders who are willing to be fettered within the confines of the law. That's when you have predictability, because we see a situation where we do have the laws, and right now there is what I think we can call structured impunity. Of course, the key point for me, of course, knowing the work that I've done around women, is to see how the Constitution 2010 recognizes women as bona fide citizens, which the 62 Constitution did not. And I think that the echoes of the former are still with us today, that despite the framework, we're still having to explain or negotiate why women still need to have equal opportunities as men. And the pointer, when you talk about how the colonial constitution or the colonial arrangement was such that development didn't go to areas that were deemed not useful to the colonial class, they couldn't extract from them. And so now we listen to the debates that are happening in Parliament with the division of revenue, and we see these same arguments. And so with that, let me just see, because I can see that there is a question from Ndungu Wainaina. He asks, what is the motive behind the lie, the political claim, the bill's BBI proponents, that the Constitution 2010 does not provide inclusion? So before you answer that, you talked about the secret weapon. I remember that Moi used to use that phrase, that he had a secret weapon, and that was the promulgation of Parliament, so that was a means to keep the members of Parliament in check, so that you just don't wake up one day and he has prorogued Parliament and called a snap election. However, today we are faced with a possible dissolution of Parliament, right? For the failure to implement the 2/3 gender principle and to abide by the court order that gave 60 days for it. And now LSK is pushing. And so as you answer Ndungu Wainaina's question, I think I would want you to weigh in, or at least even try and give us a scenario of what we're looking at, because this is still part of the politics of constitution making, because we are here with the 2/3 because the political class have refused to implement the Constitution or even show fidelity to that Constitution with regards to the 2/3 gender rule. And now there's the Chief Justice is faced with the responsibility of abiding by the Constitution. And so is there a possibility, because the way the transitional that clause 261(7) is framed, is that if Parliament fails to implement legislation at according to the time frame given by the courts, then the Chief Justice shall advise the President to dissolve Parliament, and Parliament shall be dissolved. So, is there an opportunity for the Chief Justice not to advise, seeing as Parliament has not? And if he does, what kind of a scenario would we be looking at? You know, even as you talk about that, even as you answer Ndungwa Naina's question.
Okay, so I think it's important to look at both these issues within the context of the principle of the rule of law. It's one of the things I didn't mention. In fact, it's ironical, I think, because for me, this is the primary challenge that Kenya has with its political elite, that we don't have respect for the rule of law. And so I think it's something I'm so used to that ironically, I actually didn't mention it. But I think this is at the heart of our problem. At the end of the day, the question of the 2/3 principle is fundamentally about also enforcement and respect for the rule of law. Under the Constitution, Parliament is required. It doesn't have a choice about this. It is meant to have enacted and put in place a formula that would ensure that at least 1/3 of the members of Parliament are of the opposite gender. Currently, we have less than 1/3 members of Parliament who are female. Mm-hmm. There is no difference between this, for me, and actually the issue that Dungu is raising around the principle of inclusion. Because the principle of inclusion, gender equality is an aspect of the principle of inclusion. When we talk about inclusion, it's not just about ensuring diversity on the basis of ethno-regional diversity, of ethno-racial diversity. It is also diversity under the Constitution. The Constitution clearly recognizes diversity on the basis of age, diversity on the basis of gender, diversity on the basis of ethno-regional communities, diversity on the basis of disability. Parliament is meant to bear the face of Kenya, and not just Parliament. All of our appointive and elective bodies are supposed to bear the face of Kenya. The Kenyan people do not just belong to one sex. The Kenyan people are not just one ethno-racial community. The Kenyan people are not just, the Kenyan people are differently abled. The Kenyan people are diverse. We're not homogeneous, we're heterogeneous. There's so many of us, we look different, we speak different languages. And so this is supposed to be represented because public office is a public good. And so all of us in our diversity are entitled to be part of the governance of the Republic. And so for me, the challenge lies not in whether or not the Chief Justice was to rule and the Supreme Court were to rule today, and the Chief Justice was to call for the dissolution of Parliament. Do we have a political elite that will respect that ruling and that decision of the Chief Justice? That for me is the question. And so the crisis I think that Kenya faces today is that we have a political elite that does not respect the rule of law. There are countless examples of decisions of the courts, I think, that have not been respected and that have not been followed and implemented. And so we have a challenge around implementation. And so to bring myself now to Dongu's question, the Constitution in its current form, under Article, I will just speak to the executive and just ask if any of you has a copy of the Constitution in front of you. Just look at Article 130, sub-Article 132 of the Constitution. Article 130 talks about the composition of the national executive. And under Article 132, sub-article 2, it says the composition of the national executive shall reflect the regional and ethnic diversity of the people of Kenya. Shall reflect the regional and ethnic diversity of the people of Kenya. And so, aside from the general principles around inclusion, that we have specific principles embedded in relation to different organs of the state. In relation to gender and persons with disabilities, it's important to again look at that within the context of Article 27, which provides again that at least 1/3 should be of the opposite gender. Now, when you look at the composition of the cabinet, does it reflect these principles? Do we actually have an ethno-regionally diverse cabinet? Do we have any persons with disabilities in the cabinet? And this is appointive office. It is easier with appointive office to ensure respect for these principles than it is with elective office. And so what I am left with, and I agree with Dungo, it is a lie that the Constitution does not provide for inclusion. So what I'm left with is that if in this limited form, if the political elite is unwilling to respect and obey those principles in their current form, what guarantee is there that they will obey them should we amend the Constitution? Have I answered the questions?
I think so. I mean, I think it would be, I think you have. I hope Dungo is satisfied with your answer. And so this brings me to now the BBI, okay? And you know that you've given us a very good history of how we came to the Constitution 2010, which we will be celebrating a decade of. However, we know that one of the things that sort of like pushed the political hand was the tensions that were in the country. I mean, we know that 2007, 2008, Kenya was literally at the brink of self-destruction. And so the politicians were forced to sit down and they had no way out. They were sort of like painted into a corner. And of course, as you rightly say, the people really then forced this on the political elite, the new constitution on the political elite, because over the years they had demonstrated their reluctance towards, reforming the state and the supreme law of the land. However, now we have the proponents of what is now called building bridges. And of course, the argument is that we came to a point of almost that destruction, because we all know the scenes post 2017 general election, the electoral dispute, which was similar because even the 2007-2008 scenario was also as a result of the electoral dispute. And so now here we have the famed handshake and the 9-point agenda aimed at building bridges with a very central theme, seeking to amend the Constitution and bring about what they are calling inclusivity at the executive level, so that the political tensions that arise post-election are dealt with and that everybody has what they need. So when you look at BBI, the rationale behind BBI, or what is given as the rationale behind BBI and the intent, how do you view it in light of our history and the politics of constitution and constitution making in Kenya?
Okay. So I want to, because again, I think both you and Dungo gave us a very good basis with your two earlier questions for the question that you're raising. So I want to read out a couple of provisions from the Constitution and then go into why I think they're relevant to this particular discussion. So Article 1 of the Constitution of Kenya, Sub-Article 1 says that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. Sub-Article 2 says the people may exercise their sovereign power either directly or through their democratically elected representatives. And then it proceeds to delegate sovereign power to the organs of parliament, the national executive, the judiciary, and independent tribunals. Then I want to go to Chapter 6 on leadership and integrity, where it says responsibilities of leadership. Authority assigned to a state officer is a public trust to be exercised in a manner that is consistent with the purposes and objects of this Constitution, demonstrates respect for the people, brings honor to the nation and dignity to the office, and promotes public confidence in the integrity of the office, and vests in the state officer the responsibility to serve the people rather than the power to rule them. I jumped there because it's an articulation and an expansion of an earlier provision. And then I hope that you're all remembering the provision on inclusion that I have already spoken about earlier under Article 130, Sub-Article 2, which requires diversity in the composition of our cabinet and of the executive. So I perceive, and here I am speaking just from a personal perspective, I perceive I perceive public office as a public good. And I think this is encapsulated in Article 73, about which provides that it is the power to serve, not rule. It vests responsibility to serve rather than the power to rule over the people. And so the test, when we look at any process that seeks to amend the Constitution or any law in this country, or even create policy in this country, the first test is public participation. To what extent was the public consulted? Did they participate in the taking of that particular decision? I perceive, and so with respect to the BBI, the first challenge for me is this something that is a need of the public, or are we witnessing once again an attempt faced with a mandatory transition, an attempt by the political elite to renegotiate the terms of office? Remember, it is this same political elite that insisted that we should have a presidential system, that now wants to walk away from the presidential system. Now, what are some of the checks and balances in that presidential system that may provide a challenge in a time of transition? First of all, under the Constitution and under the presidential system, the president only has a maximum, can only serve for a maximum of 2 terms. He is not eligible for re-election into office once he has served those 2 terms. Under a parliamentary system, they aren't necessarily terms of office. One can enact terms of office into it, but traditionally, they aren't necessarily terms of office. And I'm going to move away from Kenya. When you look around us, whenever incumbents have been confronted with a requirement that it is time for them to transit, one of the greatest areas of contestation in most African states has been that requirement. And so you see attempts to remove those presidential term limits. And so, with all due respect to Kenya's political elite, one of the questions I'm left with is, are we looking at an attempt to negotiate the way out of those term limits? This for me is further buttressed by the fact that we have an example in Russia where Putin left as a president and came back as a prime minister. And so one of the things that we must demand as citizens is that should we have a situation where the system of government is being changed, nobody who has held the office of president under any of the previous constitutions will be eligible to hold that office again, or the office of prime minister. I am also concerned that should we then choose to have a parliamentary system, one of the things we must maintain is term limits. It is possible to have a parliamentary system and have term limits within it. That's the situation in South Africa. Most people don't realize the South African system is actually a parliamentary system. That's why the political parties have the kind of power they have. Now, again, what kind of system is BBI seeking to propose? The first report that we saw last year was a report that made reference to something they were calling a prime minister, but it was, again, not a parliamentary system. Because in a parliamentary system, the prime minister is the head of government. The head of government and the head of state are separated. The president is the head of state. You cannot say that you have a parliamentary system and have a prime minister whose powers are circumscribed in the way that they were proposing or appeared to be proposing. So I'm not sure what they've come up with now, but my fear when I saw that system, what they appeared to be proposing originally, it seemed like it was an attempt to return us to the mongrel that we ran away from in 2010, which did not have any checks and balances on it. Whereas I once was persuaded that maybe a parliamentary system would be better for the Kenyan people, at this point in my life, to be quite frank, I don't hold the view that the issue is the system of government. I think that the problem we have with Kenya's political elite is a persistent refusal to respect the rule of law. And so I don't believe that there is anything that is so earth-shattering in relation to the system of government under the current constitution that requires amendment. That would not be my priority in 2020, under Corona, with an economy that is so battered, with a population that barely has access to health services, to education services. I don't think that there is anything earth-shattering in the Constitution right now that should have it take constitutional amendment, take priority over the issues, the other issues that are facing the people of Kenya. I actually don't think, there are issues with the Constitution, but to me, they are not sufficient that they would warrant some form of amendment right now.
Oh, thank you so much, Atango, for that. I can see there's a question here from Dungo, and Dungo says, each chapter of the Constitution is has underpinned principles of openness, inclusion, participation, and equality. Article 27, Articles 130, Articles 232, public service, and Article 238, security, read together with devolution, all provide the mandatory inclusion. So what exclusion that BBI politicians are talking about? So what exclusion is this that the BBI politicians are talking about? BBI narrows down to the one single issue: restoration of old order systems and politicians control and have free control and to have a free ride in doing what they want and repeal Wanjiku power over them. Secondly, it's a tool of drafting a formula, self-preservation bottom line. So it was more of a comment. I can see in the chat from Agan Odero, and Agan Odero is asking, Atsango, what is your reading of the contemporary Kenyan populace wokeness in quotes, and readiness to actively engage in wresting state capture from the political elite formations we have now? Remember how long, tedious, and fatal the previous struggle has been. Do you sense popular consciousness about this and readiness to engage? He also had asked the previous question. By the way, he thanks you for the very detailed, clear retrace of Kenya's journey towards birthing of the 2010 Constitution, and says it was a torturous, long journey with heavy prices paid along the line. So now, do you think this new current Kenyan populace are really privy to the fact that it is wartime again? That it needs readiness to face the political elite with their scheme to claw out their interest by tinkering with the Constitution? I don't know. Perhaps you could answer that. you could say something about his comments, Agan's comments.
Okay, so just one little thing. First of all, in reference to Dungo, because I realized that there's something I had wanted to say that I didn't say earlier. So yeah, I agree. I agree that that is a comment from Dungo, and I agree with the sentiments expressed in Dungo's comment. That is precisely my own perception of the BBI process. I just wanted to point out that what bothers me, therefore, about BBI, that process is the opacity. The people are not participating. We have a couple of individuals who are very powerful, who've decided for themselves that they have particular concerns. And then they're going to bring to us these concerns. So I am left in a space where I feel that as a public, we're being asked to endorse and rubber stamp their positions. And they're only doing so because under the current constitution, there are things which you cannot change without going back to the public. Mm-hmm. There are provisions in the current constitution that are entrenched, which means you must have a referendum. Even if the political elite through parliament agrees on something, it still has to come back to the public and go to a popular vote. And what this all says to me also is how distant the political elite is from the public in terms of the public's needs and the public's actual concerns. So that's all I just wanted to say that I had not said earlier. What concerns me most about that whole process is the opacity. The fact that we actually are waiting as a country for the president to look at the BBI report, and then we will be told. If this, public participation as a principle says that we should have been the ones that were raising these issues. Because at the end of the day, when it comes to this, the president is just but one of us. He is just but one of the 50 million or so Kenyans. On this, he is not above the rest of us. On this, he becomes one of us. And the same applies to the former prime minister. The same applies to any member of the political elite. Every single Kenyan has a right to be part of, no matter how stupid, how silly we may think that particular individual his opinion is. They have a right to be part of that process and to be part of that decision making. And so that's why, to me, there is an attempt here. The bigger lesson and the bigger clawback would be that we would be going back to a situation where, again, it is the political elite that decides. And we as the people are not we are onlookers who then are used as a rubber stamp once the decision, which has already been made someplace else, has been arrived at. As to whether or not the public is woke, I worry that the Kenyan public is tired, that they're fatigued, and that there has been a constant and consistent wearing down of the public. I'm not, I cannot say whether or not generally as a public we are woke. When I look at social media, there are places where I see very clear, active, engaged conversations, demanding implementation, demanding fidelity to the Constitution as it is today. To what extent those are expressions of the public at large, I don't know. I don't know whether these are expressions of a particularly conscious segment or segments of the public, or whether we have a general public that is conscious. And then I worry that, there's been some interesting writing on how pandemics can actually be very useful to authoritarian regimes. So I worry that with the current pandemic, things like demonstrating, you just have very basic concerns like health. Are people able to gather out? Not, so there's a very easy justification which as responsible citizens, we all accept for, to some extent, suspending some of our rights that are crucial to defending our political space. So I think one of the challenges for those of us that are vigilant, and remember that under the Constitution, under Article 3, all of us have a responsibility to protect the Constitution. I think one of our challenges is how do we, in this space, in this current space, with all the challenges presented by the coronavirus pandemic, how do we ensure that that is not used as a cover for corruption, for a rollback on our rights, for a rollback on the gains in terms of the democratic space that we had built? And so I think we have a challenge. I don't have an answer to it. I just think we have a challenge in terms of ensuring that we protect whatever gains we had made, and we ensure that we don't have a situation whereby this now becomes an excuse for the public, the political elite not respecting the basic principles and norms that we had begun to institute as a nation.
Thank you, Atsango. Wow, even just listening to you, the example you give of Putin and how surreal it is, you recall that one of the political elites, well, not so much political, but affiliates, actually stated exactly that, we could very well do a Putin-Medvedev. And so I think it's all fair game. I like that you also touch on COVID, how COVID is being used to circumvent the law and shrink the political space. But having said that, there is a question that has come in before I ask you what I also wanted to ask. Steve Guru is asking, if, as is widely believed by Atsango and many commentators, it is possible for a political system to suffer capture by the elite, then is it not time to rethink our democracy that largely borrows from Western liberal democracy and perhaps adopt a new form of political thought that fits the state of Kenya? You hold that thought as you answer that question. Dongo Wainaina makes reference, because a lot of people have asked about the participation of citizens in the BBI talks and the manner in which it was framed. I think that Okia Omtata even went to court.
Mm-hmm.
I don't know if the case is still alive, but arguing again about the process by which they are seeking to amend the constitution doesn't abide by the principles in the constitution, because they've framed the issue themselves. And so it starts out as though it's a popular initiative. It's only that the people who are fronting it are actually duty bearers at the highest level, the presidency, and we have the former prime minister, and they come up with this idea, but they begin to expend state funds, to engage the people, to call for meetings. And as Ndongo Wainaina points out in the chat, BBI held talks with 7,000 people who were largely politicians, state bureaucrats, and it was by invite only individuals. It had nothing to do with Kenyans. Okay, so the argument could be that those are Kenyans, that the politicians are representing Kenyans, because as you rightly pointed out, that the people exercise their sovereignty directly or indirectly. So the politicians, the members of parliament represent Kenyans, and so by extension, the people's views and voices were represented. So there's the issue of participation and the way they've been going about it. The task force going around the country, the provincial administration mobilizing participation, and then you had these participatory meetings, invite only, and then the rallies. So they could argue that this was popular participation, this was public participation. And so is there a way that they can get about that? I see there's, I think, yes, Ndungu Wainaina says that COVID-19 has unleashed a tidal wave of state power. The rulers are using the COVID-19 pandemic as an excuse to grab more power. They are suspending parliaments and turned themselves into lawmakers. Courts are being shut down. They are militarizing, securitizing governance. The state is using politics of manipulation and propaganda to cause governance dislocation and authoritarianism. Atango, before I give the floor back to you, I would also want you to comment about what we are seeing, a very dangerous precedent, where we are seeing the militarization of civilian positions, and by active military. We've seen the NMS, the Nairobi Metropolitan Authority, being taken over rather unprocedurally and being supervised by the military, who report directly to the president. And if you've read the BBI report, you see that one of the recommendations is for Nairobi to operate in the manner that is being operated now and supervised by a cabinet secretary. So when we talk about checks and balances, particularly given the separation of powers, where the Constitution of Kenya within the framework has separated the executive from parliament and from the judiciary so that they are able to operate as co-equal arms of government, we are not seeing that. In fact, we see a situation where parliament really doesn't play its role, whether it's in terms of representation, oversight of the executive, or custodians of the people's purse. They have failed miserably. But we have also seen a deliberate weakening of independent institutions, those institutions being populated by people who do not exercise that independence and essentially wait on orders from above, as it were. And that's what we were trying to get away from, the orders of above. We're seeing the police, the IGP, literally taking orders, constraining anybody or coming against anybody or groups that are saying anything that the government deems inappropriate. And so how do we deal with this? We're looking at the continued weakening of the judiciary and serious attacks against the judiciary. So how do we deal with this? What possible options do we have as citizens? And what are your thoughts around this?
Okay. So, sorry. So that was a lot, Daisy. I'm wondering, do I start by responding to Steve Guru? Do I start?
Yes, just respond one by one in the order with which I put them out there.
Okay, so my only fear is around the last one, so you may have to remind me.
Okay, I hope I'll remember. Okay.
Yeah. So let me first of all go to Steve Guru, who wants us to rethink democracy away from the Western model. So I agree, it's an opportunity to rethink, but this is precisely what I was saying about we have a challenge. I do, and I think that's the challenge to us. It's what they say about, that old cliche, the price of freedom is eternal vigilance. We have to stay vigilant. We have to understand that the battle for the democratic space did not end with the promulgation of the Constitution, because we now had the legislative framework, we now had the statutory framework, we now had a liberatory constitutional framework. But now the challenge of ensuring the respect for it was born. And the Constitution is living. It lives through us. If we sit back and wait for it to implement itself, it's not going to. It doesn't work that way. So we as a people have to constantly demand that it's respected. We have to demand that our political leaders conduct themselves in a manner that respects the norms that we have said we want to live by. And to some extent, I agree with Stephen about this being Western, that we've borrowed from Western democracy. But on the other hand, I think that some of these things it's not about Western democracy. If we look at our own traditional ways of governing ourselves, everybody had a say, particularly, and by everybody here, let me speak from a very clear gendered perspective. But if you look at our older, in our older societies, who is it that then determines how things happen, the norms that govern our communities? It's older people. And they have a say just by virtue of belonging to that community and having fulfilled all the rites of passage that enable them to graduate into the stage in life where they determine how things are run. So the notion of democracy itself is actually not that alien, particularly because if you look at Kenya, unlike our neighbor Uganda, for example, or Rwanda, Kenya only had one monarchy. So one of the things that baffles me is how Kenyans have began to evolve a culture where they're creating an elected monarchy, where you see people being elected because, their spouse or their sibling or their parent previously held a particular office, We, in a way, are donating, I think, freedoms that somehow we seem to be taking for granted, that are actually, I would understand if we came from a culture where, if we lived in a country where the predominant cultures were monarchical, I would understand this. But it appears that somehow through the socialization process of that colonial state, we have somehow, somewhere decided that we are not as entitled to these freedoms and to having a say in our governance. And so I think, again, there's a challenge in relation to that. I can't say anything else. I do think, I agree with him that, we have to rethink, because I think many of the rules that we knew about how you ensure respect for the law have actually been broken and thrown out by the political elite in their constant tussle. I think we also need to understand that there will always be this contestation. There will always be people who seek to arrogate to themselves the power. And so we as a public have to put in place those checks. Domu's remark about the 7,000, again, for me, there's a contradiction there. How do we speak of public participation and yet it's invite only? Does that satisfy the requirement for public participation? And maybe it's time for us to seek some court decisions around, some guidance around what is public participation, to seek to find a way to put in place some minimums for what constitutes public participation. But for me, definitely, I do not see how anywhere in the word invite and public participation are one and the same. There are some rules around public participation, that already exist. When you look at Parliament, for example, if you're seeking, if a member brings a bill, the effect of which would be an amendment to the Constitution, there is a requirement, even within their own, within the House rules themselves, that there has to be some public participation. The challenge is more around ensuring meaningful public participation, and ensuring that even those basic rules are adhered to, because for me, BBI did not even satisfy those, those basic norms as laid down in their minimal form without even being teased out. I think because the committee the task force had already been appointed, and I don't think its original terms of reference were to collect views on amendment. I think these were all afterthoughts. It occurs as if there was a conversation, and then somewhere along the line they decided to try and ensure some legitimacy by now coming up with ideas like the task force, and then even the task force going around and asking for opinions in it of itself was also an afterthought again. And one of the questions we could ask ourselves is, has Agenda 4 of the National Accord ever been fulfilled? We've already had those decisions amongst ourselves about looking at the issue of inclusivity. You wouldn't have we wouldn't have had the kind of conflict that we did in the 1990s, in 1992, in 1997, and in 2007, if we actually had respected the principle of inclusion. And so right now, the challenge for me is not around constitutionalizing that principle. I think the principle is already constitutionalized. It's giving it life, it's realizing it. And you don't realize it through an amendment. You realize it by creating a culture of constitutionalism, of respect for the law. If the president, for example, had respected the basic principles in the constitution of his cabinet, there's nothing that stops him right now from ensuring that inclusion within the executive. Now you have to remind me of your last question.
My last question, and because I can see the clock is winding down very, very fast and we're almost coming to a close. So I will give you my last question, and then there's some other questions that have come in. Do you think that I can give you my question and the ones that have come in as well? Or do I?
Is it possible to summarize those ones that have come in?
Yes, I'll try to. But for me, I was talking about the checks and balances. That among the things you've talked about is the checks and balances that the Constitution gives us. However, we have seen those checks and balances not working. The Parliament is a puppet of the executive. The executive disregards the judiciary, threatens it at every opportunity. The independent commissions are not really working at their optimum, and they have been populated by individuals who cannot exercise the independence as envisioned, including the security agencies such as the police. And so what are we to do in a situation like that? That was, I mean, what options do we have? Yeah, maybe you answer that while I look at these questions in the Q&A and summarize them for you.
Okay, so I think we must continue to resist the attempt to claw back. Last week, for example, there was an excellent decision that came out of the court with regards to the independent commissions, whereby there had been an attempt to put in place by the executive to put in place an order that put the judiciary as well as independent commissions under various ministries. So it's important that every single time any of these attempts is made, people go to court, people challenge these decisions. It's not always necessarily by challenging it in court, but people consistently rise up and say, no, this is not appropriate. The other thing that for me has been a learning point, again, as a younger person, and I think in the earlier work that we did around the Constitution, we thought that the only issue was institutions, that if we had the right institutional framework, we would be okay. One of the things that I have learned now is that when you have a nascent constitution and nascent bodies, who is appointed or who is elected really matters. And so the Kenyan people have to stand up and start really looking at who we offer the opportunity, the privilege of being elected representatives. We cannot continue to know, for instance, that somebody has consistently, throughout their time in public office, broken the law, violated the law, and then we give them the privilege of them being a lawmaker. Or somebody has a history of theft, of engagement in criminal activity, and we elect them to be the guardian of our resources and to be a governor or to hold an office whereby they will be responsible for the public purse. So there is a lot of work that needs to continue being done in the area of civic engagement, in the area of conscientization. I don't think this is something that will be sorted out overnight, but I do think that it is important for us to consistently resist and use the mechanisms that exist whilst trying to consolidate and create new mechanisms for ensuring respect for the rule of law and for increasing our democratic space.
Okay, thank you so much. Yes, indeed. You have answered the question, of course, throwing the ball right back to the citizens. So let me just, Branham Dogo has been saying, and I think you made a reference to it in your comments about the referendum. There's been talk of having a constitutional referendum before the year ends. Given that COVID-19 has a majority of the population eking out a living and basic surviving, does civil society have the capacity or stand to create awareness against the planned referendum? Then Dongo says, if we genuinely want to address the gaps in the Constitution 2010, there is a way out. Full implementation of the Constitution and upholding the rule of law it underpins. Secondly, conduct comprehensive audit through an inclusive and participatory process on what we have implemented and lessons we have obtained from implementation. Thirdly, outline all aspects of the Constitution we have not implemented. Fourth, agree on process of addressing identified gaps. Finally, Edward Muriuki says, the political elite can use this pandemic to circumvent the gains made so far by the Constitution and the social justice activists. And given that the best form of defense is to act, do you think that this also gives us an opportunity to react accordingly? Madam Atsango, over to you. And as you answer those questions, I think you can also make your closing remarks. Yes, I think that because we have about 10 minutes, so you can answer those questions as well as make your closing statement.
Okay, so I consider those 3 questions to really be more of comments. I do think that we need to understand that when you have a country where we've had a culture of authoritarianism, because that is Kenya's political culture, it is one of authoritarianism, initially by the colonial state and continued by the post-colonial state, but by the post-colonial regimes. And so there will always be an attempt to claw back and regain the powers that those political elites enjoyed. I don't think the solution lies only in the law. That law has to be given life, because law is just a documentation of the norms and principles that we have agreed that we want to live by. And so we, I think, as citizens need to understand that without vigilance on our part, and I cannot say this too much, without vigilance on our own part, we are going to continue finding ourselves in a situation where this small elite continues to benefit. And of course, they will want to hold on to whatever they're enjoying. It's just human. And so we have a responsibility to ourselves to understand that Kenya is as much our birthright as it is that of the political elite and those little cliques in the political elite. The presidency is as much the birthright of every single Kenyan as it is of those who've held it. And so we must demand that this being public goods, then we as a public are entitled to enjoy those goods. They cannot be arrogated to small pockets of our populace. Now, we've been in these places before. I think that was the purpose of going into that history. So what did the Kenyan people confronted with similar circumstances do in 1997, for example? We set up our own parallel processes. We monitored, we watched, and we demanded. So we have to organize. We had documents ready of the kind of constitution that we wanted. And we therefore were able to determine the kind of constitution we ended up with. And I think we need to remind ourselves, yes, we've reminded ourselves of the challenges that we are facing, but we need to remind ourselves that also faced with similar circumstances in the past, we have risen up. And so those are some of the tools. Do we, for example, pay attention to and monitor when public officers are coming? Did we, for example, as citizens, through civil society organs, etc., have a list of alternative auditors general when the interviews were taking place? Did we demand that there would be a proper interview process that respects the constitutional principles around advertising, around the interviewing processes for these officers, around the appointment? And so we need to develop not just the ability to monitor what is happening, but also to put in place alternatives and to offer alternatives for these processes. And we must speak out loudly and support those who are speaking out on our behalf. In our own spaces, in the spaces that we control, do we respect these principles and norms? In our own civil society organizations, do we respect principles and norms of inclusivity, for example? Do we respect principles of democracy? Are we creating spaces where we are equipping and constantly ensuring that even if one of us falls, there are those who are able to step forward and take up those places? Do those of us who are educated and understand the Constitution, do we take the time to provide information and share that information with other people who may, for example, lack the skills to read? What are we doing in our own spaces, in the spaces that we control, to ensure that we bring about transformation in our country? And so that's the space I want to leave us in. This is not a battle that will end overnight, but I think we must continue to be vigilant, and we must continue to demand a democratic and truly free Kenya, in which every single Kenyan goes to bed, has a bed where they can sleep, in a home that respects their dignity. They actually have a home that they can go to, that they actually have food on their plates, and should they fall ill, they have access to proper health care, and that their children will have the opportunity of education. Thank you.
Thank you so much, Atsango. This has been really wonderful. I'm so shocked at how fast the time has gone. I feel we've only touched the surface of things. I could listen to you all day, because really, you're full of history and wisdom. Before we wind up, before we close, let me read some of the comments that have come through the chat. Sheila Masinde writes, Atsango, write that book on the Constitution of Kenya 2010. Very well articulated. Seeing the blatant disregard to various provisions of the Constitution by the political class, there's need for greater appreciation of our constitutional journey to inspire understanding of constitutional provisions and the respect for the rule of law. Isaiah Biwott says, the political elite are actually operating like a cartel, or are actually one. We citizens should wake up and challenge the cartels who look more organized and know what they want to control the masses. He goes on to say the elected political monarchs are actually calling themselves political brands that should lead the others. Wambua Kawive says, I am the richer for this webinar. With the executive rogue, the judiciary intimidated, the legislature dead, should we call for the dissolution of government? That's a question, a pertinent one too. Isaiah Biwott also says, we Kenyans are equally to blame for electing thieves and suspects to public office and rejecting people of integrity because they don't have or don't bribe the electorate. Winnie Maru says, thank you, Atsango. That was excellent. And that is really a great place to wind up. Indeed, Atsango, it has been excellent. It has been a great honor to moderate this session with you, and just to go through the history, the rich history of constitution making in Kenya, and to understand the politics. Clearly, the politics has not changed, which means then we must be more vigilant. And the truth of the matter is, we have dropped the ball. I think for many of us, we believed that the promulgation of the Constitution 2010 meant that we had come into Canaan, but it looks like actually we only left Egypt. We are in the wilderness. And with the political elite being rogue, I think we need to step up. And I like what Ndungu is saying. He says we need intensive community Katiba study groups. Yes, we do. And we know that there's been threats to, if you want to do civic education, it's not appreciated. But I think that the Constitution should be taught in schools. People need to learn this journey. They need to understand this journey so that we appreciate what we have in the Constitution of Kenya 2010. And Atsango, you remain a legend because you were part of the team that actually birthed that new Constitution for us. And we appreciate you. Continue doing the good work. And please, Atsango, it is time to come back into the trenches. It's not over till it's over, and the threats are real. And so I'm going to find a way to bring you back out into the active space. You'll retire when the inevitable comes your way. Eternal vigilance is the price that we pay. We must step up to that. We must step up to that call. Thank you so much. And thank you so much to Inuka Kenya Nisisi for this wonderful opportunity and for these webinars. And I will close by saying, Tekeleza Katiba, Let this be the clarion call from us all in civil society, from us all as Kenyan citizens, tekeleza katiba, because it is by kutekeleza katiba that we are going to enjoy those rights. Thank you very much. Have a wonderful evening.